privilege to examine this important topic, regulatory practices, in Nigeria, or contemporary regulatory practices in Nigeria. For purpose of interaction, we'll be looking at three major laws or acts: the Labor Act, the Pension Reforms Act, and the Employee Compensation Act. By the time we look at these three major regulatory acts, we will now begin to benchmark one, in our organization, how are we doing it and how are we complying to regulatory practices? Two, as individuals, how much of the regulatory laws do we know? Three, in the larger society, how have we been allowed to implement, to execute, and to practice? What does that mean? It is possible to know it, but the environment is not allowing you to execute. Two, it is possible we know it, the environment allows execution, but we are not properly interpreting the content of the regulations in line or in ways that do not subject us to avoidable litigations. Let me say that you do not have power over litigations. You only have power to minimize exposure to outcomes of verdicts. Because litigation is not just a function of you, it's also a function of the second party. If the other party chooses to go to court, you can't say, no, don't go to court. You can't say that. Even if you say, let's settle out of court, if he says, no, I'm going, you can't do anything about it. So, but the court has the final authority to interpret your policies, to interpret your practices, and to interpret anything you do in your company in line with the provisions of the law, with the provisions of various practices. Therefore, whether what you are doing is right or not, let's wait until we get to the court. However, before we get to the court, we can take a lot of insight and guidance and support from the law. When we take enough insight and guidance from the law, then we will sufficiently reduce tendency to have one, internal grievances; two, avoidable litigations; three, avoidable consequences; and four, avoidable dents on corporate image; and five, avoidable embarrassment on ourselves as a practitioner of human resource management. Let's begin by first and foremost looking at the first, which is the Labor Act. Now, let me say this very quickly, that Nigeria is a signatory to the ILO Conventions Act. That suggests that Nigeria is a member of International Labour Organization, one. Two, Nigeria also is a signatory. It consents to the ILO, the Geneva Convention. Meaning, most of the provisions of the ILO Act are binding on Nigeria. And the next thing we can also take as insight is that the International Labour Organization is to provide a generic global standard for labor practices, of which our Labor Act or our labor practices is also part of the ILO provisions, but we localize it in the ways that applies to the practices in Nigeria. Labor Act is also a product of the 1999 Constitution and the federal laws. In other words, Labor Acts are not governed by state laws, but they are governed by the federal laws. Whatever is federally gazetted, promulgated, and sanctioned, passed and approved, applies to every corporate entity in Nigeria. Therefore, it is important for us to look at all these laws and how they apply to every single person. As I mentioned, in particular, how they apply to you as a practitioner and how they apply to me as a consultant and how they apply to employees, because the employees of today are well informed about the provisions, about the activities, and about the directions of the law. What are the contemporary labor practices? Now you will see two things. I am talking about contemporary practices and the labor itself. So you will find two things coming together. The practices we have seen around us happening in our organizations, happening to other organizations, and what lessons and insights can you and I pick from them. Now, as I mentioned, that the Labor Act is primarily a legislation that is coming from the Federal Republic of Nigeria, and it deals primarily with the relationship between employees and employers. And this has been governed by quite a number of dynamics. Why is it dynamic? Two people, different organizations, commit the same offenses, and the court will award different sanctions. Why? Because law will look at equity, fairness, and justice. And law will look at so many circumstances in those issues before it gives its verdict. It helps employers, on the other hand, to understand the provisions upon which they have to act as the employer. What are these provisions? The law also is very instrumental in determining that, you see, the organization is not a human being, even though it's an artificial human being. But employee is a human being. It suffers physical, mental, psychological, emotional feeling impact. But the business, the company, does not suffer emotional feelings. So the law will always look at who suffers most. What are the major highlights of the Labor Act? We can't look at the entire Labor Act, but let's look at the highlight. Number one is forced labor. So the question is, what is forced labor? As I said, the Labor Act is also a product of the 1999 Constitution. And under the 1999 Constitution, every human being has rights to life and has right to determine where they want to work. That is why the first thing you will find in the law is that you cannot employ a minor. Who is a minor? Anybody below 18 years does not have the full constitutional right to take decision for himself or herself. Therefore, you cannot employ anybody in your organization who is below the age of 18. If you employ anybody below the age of 18, then you have committed a very serious offense, and that is you have abused human being. And that constitutes forced labor. What is another forced labor? When I'm arrested, when kidnapper kidnaps somebody and say, we have kidnapped a doctor, come and be working for us, against your will, against your interest, it's called forced labor. Have you noticed that everybody that wants to work in your company say, go and write application? Do you know why? Because the law will say, did you force him or he applies on his own? You say, no, we didn't force him. You see, I hereby apply on my own. I wasn't forced. I hereby apply to your organization. I voluntarily will to sign an employment with you. So that's why you request for employment letter. That is to say, you apply on your own. The job was not given you as a gift. It was not a gesture. It was not a replacement. But I voluntarily apply. And as I mentioned, when you bring a minor to your organization, it will also represent forced labor, because the person does not have the right and the franchise to decide, I want to work here. So it can be termed that the parent forced the person. You force the person. Uncle, auntie force the person. So forced labor is illegal. Taking people to mine, taking people to work in the factory or in any work activities, skill on skill, against their will, is forced labor. That's why when an employee says, I hereby resign, you cannot stop the person. You cannot prevail on the person. You cannot coerce the person. He has the right to apply, and he has the right to withdraw the application. Now, another thing that you must know is that to avoid complexities because of issues, it is advisable to formalize employment in writing. Why? It becomes easier to discuss, to argue, to document, to critique, and to discount anything when it is formalized. Therefore, as HR practitioners, you will not say, MD says I should employ the person. Well, it didn't say you should not give him the document. You must formalize it. What does it mean to formalize it? It means, one, let the employee apply by himself. Two, and let him sign. Two, let him submit his credentials by himself. Three, let him fill your biodata form. That's why you say, this biodata form, I agree that whatever I put here is absolutely correct to the best of my knowledge. He is writing the application and submitting his biodata and is signing on his own. Collect data and documents. That is what it means. It means that the person is going to be issued a formal letter of engagement. You will see as we move forward. And in that formal letter of engagement, the law says it must contain at least relative minimum terms and conditions. What are these terms and conditions? Number one, the name of the organization I'm working for. You must know the company. There's not that you don't need to know. I must know the location of the company, whether it's abstract, whether it is physical, whether it is virtual. Three, I must know whether my work is virtual, is physical, or is quasi. Hybrid. I must know how much you are paying me. I must know the denomination. I must know the currency you are paying me. I must know the title of my job. I must know my position. I must know the date I'm resuming. I must know the days I'm working. I must know the hour as I must work. The Lord said, you must formalize it. Don't say, you did it. I must know the number of days of leave I'm qualified for. I must know whether during probation, if you put, because the Lord does not recognize probation, we don't approve probation there. If you put probation, you must tell me whether I'm going to serve for 3 or 4 more. The Lord says, you have to state it. You must formalize your employment. Do not delay. In fact, the Lord says maybe 3 months after. But no, as long as you are trying to bring anybody, do not bring anybody into your system. Do not rush and hurry. Oh, you're going to start work. We will give you a letter later. Do not start that. Formalize before the person employed. Do not rush recruitment. You can rush many things, but not recruitment. Formalize it. Get details. Verify. Validate. Confirm. Ensure. Take all the input you need to be sure that you are acting. Because when you get to court will request a copy of your offer letter. And that's why your offer letter has to be detailed. There is no offer letter that has 100% accuracy. There will always be loopholes. But as much as possible, cover minimum terms and conditions that will be inside that letter. And do not give an offer letter that is not signed, that is not on your letterhead. It must be signed. It must be on your letterhead. It must carry your name. The company's name. It must carry the date. It must carry the person you are sending to. Don't send an offer letter to a blank person. No name, no address of anybody. You must address to a specific person. And you must state it in his name. And you must state the salary you are paying the person, and the month is resuming, the date is resuming, the hour is resuming, the location you must work. So you go back and check, is our employment letter adequate? State a peripheral of what the job looks like. And that was why, if you remember, I said that you can add your job description as an addendum. Find attached your descriptions. But give a summary of what the job looks like. Why? Let's go further. Other issues in the labor act that you have to take consider is the payment of wages or salaries. In the West, they want you to be financially independent so that every day, every week, every month, you are not begging for money. Unlike in Africa, where most work, you have to earn it at the end of the month. But there's one thing you must understand about salary. Why are we not paying salary in advance? You know why? Because salary must be earned. You must have put in the effort and put in the skills and put in the labor before you earn salary. So you cannot pay salaries in advance, because it has not been earned. Where it occurs, you pay salary in advance is you are borrowing for the work yet to be executed, and it's on your own terms. So in payment of laws, it's salary. What does the law says? Salaries must be paid in legal tender. You must not use product as salary and say, okay, if you work for 6 months, by the end of the month, I will give you 10 bags of cement. Sell it, and that's your salary. No. You will not say, okay, I will give you our product as a salary, which is equivalent. No. You say, okay, I am going to give you a piece of land as your salary. No. I will give you a car, which is equivalent. No. Salaries must be paid in legal tender. Salary must be real money, whether it is cash or check or transfer. Not Bitcoin yet, because the law has not ratified Bitcoin for salaries and wages. The next thing you must understand is that you will not pay salary by proxy. You will not pay my salary into my friend's account. You will not pay my salary into my church. You will not pay my salary into another person until I give you a bank. I say, this is my bank. My salary will be paid to my bank, which bears my name. My salary will not be paid to my boss, who will now give it back to me. No. My salary is a personalized identity. It goes to me. It cannot even be paid to my wife except where I am incapable. God forbid the person is sick and he can't even access his bank. That's why the next of kin form shows who can get what on my behalf. The next of kin shows that you can pay to this person. You cannot say, I am his wife. Let's see our wedding certificate. It's not about that. The next of kin has proven who has right to whatever you own here. And that is why the salary can be paid to my next of kin, my wife or whoever, if I am indisposed. Or I travel to the sky, to the moon for a project, and I will come back for 6 months. So I can't even access my account. I can say, pay to my wife or next of kin. Or I'm a sailor, and I'm on the sea for 3-6 months. I'm in the battlefield. I'm fighting the Hamas. I'm fighting anywhere. I'm fighting in Ukraine. You can pay to my wife because I can't access my accounts, my ATM, my phone. I can't access them. That's why you see in the battlefield they don't even allow you to handle your phone. They don't want you to receive bad news that can devastate you, except in rare cases. So, or distractions. So that is that about wages. The next thing about wages is that you cannot pay wages in beer parlor. You cannot say, come and meet me in the disco party.